Okay, everybody, we're reconvening. Please take your seats. Zoomers, please do the same. Or whatever position you prefer. We're doing our next panel on the new cannabis enforcement laws, and there are many. We have presenting with us today Ron Naulls, who boasts a uniquely personal journey through the cannabis industry, seamlessly merging lived experience with formal legal expertise. As the author of Compassion, Consequences, and Criminal Perseverance, and the Audacity of Dope and Perseverance, he adeptly covers business continuity, governance, cybersecurity, and a multiple of legal disciplines. Ronald's advocacy roots trace back to the Compassionate Use Act of 1996. As a passionate minority stakeholder in the movement, he pioneered a cannabis dispensary in Riverside County in 2006. Yet, faced with adversity, the establishment was raided by law enforcement within its inaugural year. Undeterred and deeply impacted, Ron pivoted to the legal arena, earning his credentials as an attorney. Today, he, along with his dedicated team, champions the cause of cannabis businesses. So take it away, Ron.
All right. Thank you for that lovely intro, Ellen. So, cannabis enforcement law. So the good, the bad, and the ugly. So we're ready to dive in?
Yes.
All right. Next slide. So here, we discussed the evolving cannabis landscape from convictions to clarity. And this is rather personal to me, as Ellen mentioned, my personal plight and being raided by the feds back in 2007, and then facing federal prison time, if you will. So this convictions to clarity, as an attorney with a felony conviction, the shift with expunging cannabis convictions is deeply personal to me.
Sure.
Overcoming barriers as an attorney with the federal conviction was my personal plight, and it still is in some ways today. People don't deserve to be tarred and feathered over legal cannabis activities. For example, my moral character, when I went up to the bar back in 2015, I was denied my moral character because of I opened a medical marijuana dispensary in Corona, and the moral character committee felt that since I had broken federal law, that was moral turpitude. And so even one of the moral character committee person, I'm not going to say any names, but they mentioned to me, you sold dope. You thought you can get away with it. Just totally crushed my spirit, being in there, trying to get my law license. And then I went 2 years later. And they also mentioned that I put my family at risk, which to me at the time, when your brother is facing leukemia and dying, to me, the risk of providing cannabis to patients was to me much lower than federal indictment and conviction. Then I went back 2 years later after Prop 64 passed. Excuse my nerves. It's been a while since I presented, so the willies are just jumping right now. And probably talking about my personal experience.
Prison, yeah.
It was. I go back 2 years later for my law license, and I wasn't even going to do it. I said, why even go back and try to get my law license if they already denied me? It's not even worth it. And it wasn't for my oldest daughter, who's about to graduate from Arizona State University. She was like, Dad, you never taught us to give up, when we start something, to finish it. So I went up there 2 years later after Prop 64 passed. And what did they say to me? The Moral Character Committee, we need more attorneys like you on the bar. Completely 360. So yes. Thank you. Yes, I can't even get my words right.
60 around.
Yeah, right in the same place. Yes. So so I didn't go to law school or go to school for math. Law school.
Yeah,
I didn't say it.
Why most lawyers go to law school because they didn't want to take that.
So the significance of rectifying injustices related to cannabis convictions can be the difference between getting a law license and not, going to college and not, and going to prison and not. So that's why expunging cannabis convictions is very dear to me. as attorneys, as advocates, we have a duty to assist those who deserve a transformative journey from stigma to advocacy. So if we look at the expungement convictions here on this slide, you'll see we've been making a lot of progress in California when it comes to cannabis crimes convictions. Notably, Northern California is running the gamut. And I'm not surprised when the whole Compassionate Use Act started right here in this area of California is where it all originated, where cancer patients came together and lobbied and actually came get the Compassionate Use Act passed. It wasn't from the whole movement in Southern California, it was here in Northern California. So I'm not surprised when I see that expungements, the success rate of expungements here in Northern California are just off the charts. In LA is 96% compliant. And the California Attorney General's report says that Orange County, where Dana practices, is 77% compliant. And the worst county when it comes to expungements is Imperial, another Southern California county, 14% compliant. And I'll toot my own horn on Riverside County, we're 99.1% compliant when it comes to cannabis conviction expungements. And Riverside County voted to recall Gavin Newsom. So it's kind of weird where we're really good on cannabis expungements, but we're on the other side when it comes to other issues.
Why do you think Imperial is so low? Do you think because of the demographic and immigration status?
Great question. I do think that immigration but also I think because there's just not a lot of push in that county to get compliant. You know, there's the state is giving money for local jurisdictions to be able to have these expungement clinics and to be able to put public awareness out there. I think there's a dichotomy of public awareness and just not really motivated to actually go through and do these cannabis expungements. So, but yeah, that's a great question, Dana. 14% is really bad.
I'm so sorry if I missed this, but what regulatory scheme requires, when you use the word compliant, it's compliant with what? I'm just not familiar with.
Well, there were two laws passed at the state level, first by A.G. Bonta when he was still in office, and then a cleanup bill by his wife, Mia Bonta, which set a deadline. So it was to automatically expunge certain past cannabis crimes.
Prop 64 required expungement.
Well, but that was
But-
by, if you applied for it.
Under certain circumstances, you could get expungement, but you had to go affirmatively and ask for it.
Right.
Then the state legislature came back and said, you know what? The burden shouldn't be on the defendant, the burden is on the court system. The court systems have to go through their records and do the expungements.
For
Right.
felonies or misdemeanors or?
It's for, no. Anyone that was convicted of a cannabis crime prior to Prop 64, you look at what it would have been after Prop 64. If it would have been legal, it gets completely expunged. If it would have gone from a felony to a misdemeanor, it gets reduced.
Right. So the problem is that the counties have to take action because they're the ones with the court records. And so the counties weren't bothering to send the records up to the state, and they had no deadline to do so until Mia Bonta's bill enacted that and also required the DOJ to do quarterly reports about the status of it. And that's where Ron's figures are coming from yeah.
Thank you, Ellen.
Sure.
You're helping me get those nerves out.
Yeah, good. Give me a minute to breathe over there. Okay. Thanks for waiting all day to do this. Yeah. So, okay, we ready for the next slide?
Yes.
Yeah. Okay.
So why new enforcement laws? Well, because ensuring a controlled, ethical, and legitimate cannabis market is the whole point of enforcement laws. California normal stance is not against enforcement, but vigilant about its reach. And also protecting small, personal, and or medical grows. I'm ecstatic about what Cal Normal is doing in this area of law. And then the rising concerns with large unlicensed cannabis operators is a huge enforcement issue. Where I am in Riverside County, lots of rural areas, I see clients that call our office all the time for personal grows where code enforcement has come and tried to put liens on their property. or they're a medical cannabis grow and they don't have, the canopy or their grow tarped area 10 feet from the curb. Stupid things like that still go on in Riverside and San Bernardino counties. Enforcement costs versus lowering the barriers is also an issue. And then violations beyond cannabis, like human rights issues, the undocumented agricultural workers and environmental laws. So kind of showing some pictures here where with enforcement, where like on the left there, you have like, a little personal grow on their apartment, out on the balcony. Then you have the large scale grow, illegal grows we see in the Southern California out in rural areas. And also the environmental issues down there on the bottom left, and the trash. And then the human rights issues, mostly what I see with undocumented workers and agricultural workers that are coming from Mexico and working in large grows or in licensed grows, but they're still getting, they're not treated properly when it comes to wages, or they're paid under the table. So just things like that is why these new enforcement laws are still coming into fruition today. Next slide. So rethinking enforcement. So the adaptation over suppression. So if we look at the evolution of cannabis laws over the last, almost 2 decades, you got California, the standard barrier, and with the Compassionate Use Act back in 1996. Then you had Alaska and Oregon legalizing recreational use, Michigan. I mean, everyone pretty much knows the trajectory and the evolution. So what's the lessons that we've learned from the past cannabis regulation attempts? I think what's front and center is the equity should be front and center, where cannabis regulations harm communities of color. And I speak to that specifically as one that was harmed and as a person of color. I talk about this disparity in my book, Compassion, Consequences, and Criminal Perseverance. So a short little plug there. But you'll actually get that real life experience of equity front and center and the harm that's done to communities of color. Also, the consumer should have access to safe and tested products. That's something that has evolved over the years from the illicit market to where we are today. The costs and inefficiencies of strict enforcement, the social costs with mass incarceration, law enforcement, courts, the opportunity costs as far as education, healthcare, and infrastructure. These are still lessons that we're learning today, even when these new emerging markets come online, like New York and Maryland, for example. Advocating for reduced taxes, more accessible regulations and licenses. That's something we're still learning today. It's not something that it's evolved, but it's still something that we need a lot of work on in this area. Fair licensing and permitting process. So we've talked about that a lot throughout the day. That it not be complex, that it not be expensive, and that there's not these high barriers to entry. When I first started Healing Nations, almost 16, 17 years ago, it was $30,000 for me to get edibles and flour and concentrates. And we posted it back then. It was Weed Tracker, wasn't even Weed Maps. And now $30,000 won't even get you a security system, let alone being able to open up a dispensary or retail operation. And the fair and proportionate taxing, profitability is difficult. 280E, that's what I was convicted under, and that's still hampering businesses today. Next
Everyone
slide.
know what 280 is?
Oh, good question.
Federal tax code basically says that anybody that is in an illegal business, you still have to pay your taxes, but you have to pay on basically your gross income, not your net. In other words, you're not allowed to deduct your regular business expenses. And the federal government considers California's legal cannabis industry to be illegal federally, and so they're not allowed to deduct their business expenses.
And I know you're probably thinking like, Ron, you didn't pay your taxes? Yes, we paid our taxes. We had a CPA. He did everything by the book, didn't take any business deductions under the law. But you know what? The feds, when they want to find something, they will find something. And, you know, kudos and virtual fist bump to Cal Normal during that time, who was able to help me out as a defendant when my indictment came down.
But
So,
things that would be normal business expenses in any other business, the rent for your location, which, you know, donut place deducts the rent for their location. This place deducts the rent. You can't deduct your rent for a dispensary.
that's absolutely right. Thank you for that, Bill.
Anything that costs.
Anything that costs, yes.
Anything but.
Cost of goods,
COGS, yep.
Yeah, ironically, the marijuana is deductible, but everything else is. I mean,
But that's a retail.
ironically
Top your
and
ridiculous.
there was a fight on that one too.
We're lawyers.
All right, I just wanted to call out, make sure Laura was still on call because she's,
Yes,
okay, all right.
I'm
She's
here.
back. All right, all right, excellent. So first, we're gonna talk about the good. We're gonna go through and then we'll get to the bad and then we'll get to the ugly. So on the good, out of the laws that were passed in the past year, we had AB 1684, which is medical garden protections, and then AB 1126, fake packaging, and AB 1448, federal enforcement. So first, next slide, we'll
oh,
go.
wait, let me just, can I say one thing
Yes.
about 1684, because Lauren and I worked on that one. Actually, it wasn't all overall a good law. It was amending a law that passed a few years ago that allows for immediate fining of medical marijuana gardens. No other crime has this, is at the county level, you know, instead of issuing a notice to abate, they can immediately fine. And this bill by our AG expanded on that bad law. But we were able to get protections for medical gardens into that bill. Am I saying this correctly, Lauren?
Yes, so it was, this law did a lot of things, but basically it was allowing, local governments to enact immediate fines and penalties for certain violations of health and safety codes and non-compliance with, various things that often was catching the small grower, like Ron was talking about, with these, trivial offenses, but allowing local governments to fine, $10,000 a day and essentially be guilty until they had to try to prove themselves innocent, because the fines would start accumulating on day zero. And so that was, and while it was probably, the goal was to target the larger operations, in my experience up in Sonoma County, it was just as frequently, if not more frequently, being used against medical growers that were growing 101 square feet instead of 100, or 7 plants instead of 6 if they were adult use, and being charged as though they were an unpermitted commercial operation, because they were now considered to be commercial and they were penalized on days. And so it was a way to just extract fines from the low-hanging fruit. And it was unfortunate. And so, yeah, we worked hard to get some language added in here that would create an exemption, that if it was the operation in question was in compliance with the medical cannabis laws, if it's a medical garden in compliance with state law, then that's exempt from this. Also, licensed businesses that are fully compliant. This shouldn't be, really, this shouldn't be used as just a tool for local governments to try to make money off of operators that mean well, but are maybe committing small violations, right?
Normally, for any zoning violation, you have too much
Right.
garbage on your property. You have people living in a tent in the backyard. It's against the zoning, whatever. Under the law, they have to give you notice and give you an opportunity to fix it. Like, if you don't fix it within 48 hours, then you get fined. What happened was there was an exemption for growing cannabis. For growing cannabis, we don't have to give you any notice. You don't get the opportunity to abate. We find it, you owe the money, end of story.
Right, and there are sensible reasons someone could just pick up their operation and go down the street with it, which is probably happening, but I just wanted to say one other thing, sorry, Ron,
No,
But-
go ahead.
we got two kinds of exemptions for, well, three, one for license, one for, following the Compassionate Use Act, Prop 215. And the third was a little known and used, section of Prop 64, which is in the Business and Profession Codes, which allows someone to grow for 5 other patients if there's no money exchanged. And I've always been wanting to get that enforced. And so we were able to slip it into this bill written by our AG. And so I'm hoping maybe, we will start to see more of those gardens flourish.
Is that signed into law?
It was. Thank you. Okay, next slide.
Next slide, yes, I think,
Oh, we already did that.
yes.
Okay.
All right, so the next good law that we have is AB 1126. Now, I actually like this law because the objective of it is to combat the rise of counterfeit cannabis products. If you look on the right, you see the knockoffs on the right there, and then on the left, you see the authentic cannabis products. It looks authentic over there on the right. I mean, it looks like the real deal Holyfield to me. I couldn't even tell. But what this law does is it criminalizes the use of fake packaging for unlicensed cannabis products. And what are the implications and the benefits for consumers is the assurance of product authenticity, the reduction in health risks linked to counterfeit products, curbing untested, possibly, dangerous products, and the confidence in product quality and compliance. And then the next slide, in this one, in strengthening the regulatory insights in AB 1126. For the regulators, it's a clear differentiation between legitimate and illicit market products. For the industry, it levels the playing field, curbing unfair competition from counterfeiters. And it enhances the trust amongst licensed businesses without undermining the fake packaged products. And it also broadens the scope, with California being a mature market leader, in that it sets the precedence for other industries that are vulnerable to cannabis products. So again, I applaud California being, the first to set the market and set the stage for the real legitimate products instead of the counterfeit products that are out there. I would hear stories about products making itself out of California, counterfeit products, into other emerging markets. And those emerging markets would think that they would have legitimate products when they're actually counterfeit. So any questions, comments, cuss words on AB 1126?
No, we supported that one, yeah,
All right.
as a consumer advocacy organization, sure.
Nice. Next slide. So on AB 1448, this dealt with the redistribution of money when it comes to revenue from cannabis. So where does the money go?
Cannabis fines.
From cannabis fines, yes, thank you. So that enforcement money, that when code enforcement comes knocking on your door and you got to pay that fine, or any type of enforcement fines, where does that money go? So enforcement revenues are seen as a potential boost to fight the illicit cannabis activities at the local jurisdiction level through administrative processes. There's centralization concerns that all funds, they go to the state, of course, and then they leave local governments without giving them their share of the enforcement costs. It creates this like tug of war between state centralized funds versus local needs. So you have this divided money bag, if you will, that we're showing a picture of. You have the state of California on the left, getting a bigger, larger portion share, and then you have the local governments where they're sending their portion to the local governments. So it just highlights this uneven distribution. So the bill's proposal, it introduced a shift to help local jurisdictions more efficiently use funds to curtail illegal activities while also generating revenue. The revenue goals, of course, is to boost the fight against illicit cannabis operations. And this bill, surprisingly, it didn't have any opposition when it was brought in February of 2023. And then it passed very swiftly and it became law on October 13, 2023. And I must comment in that in my own home state in Riverside County, I've seen just the influx of code enforcement just explode, because now I'm seeing cases of, again, where a medical marijuana grow is being code enforced when, like, months ago, you know, these code enforcement officers didn't even exist. They just got hired on. So just kind of that dichotomy, in that the whole point of enforcement is to get be more of a strong arm on the illicit market, but yet you still have legal operators or your small, you know, medical grows that are being targeted by this this particular bill. Next slide. So now we move on to the bad laws that were passed in the last year, or on the cusp of being passed. So Senate Bill 753, challenging small growers, Senate Bill 756, clarity on water violations, and Senate Bill 820, shifting the forfeiture landscape. Next slide. So on Senate Bill 753, challenging small growers, this is, to me, was, you know, it deals with the small grower being, you know, made a criminal, if you will. And so this bill it poses a threat to the minor operations, the small, you know, operator, not the large MSO. Criminalizing gardens with felony charges for gardens as small as 50 plants, especially with linked water violations. There was a consumer concern for legal activities being deemed illegal, which we've discussed ad nauseum. And then overreaching water rights, Cal Norma's concerns about undue discrimination and heavy-handed enforcement. They raised that as an issue. And then the disproportionate punishments also raised concerns about targeting smaller operators, while larger operators could potentially escape scrutiny. And that was a business concern. Next slide. So Senate Bill 756. Bill, you have the floor on this one, my friend.
There were a bunch of bills that were in the legislature this year that we looked at and took positions on, and we had our normal lobby day, which went very well this year. This one, basically, they wanted to make it easier for the cops to bring in other agencies when they go into search, that can then get people in trouble for, in this one, violating the water rules, taking water from a stream illegally, things like that. They changed the notice requirement. There was previously, you have to give adequate notice. Things like, and you only have, once you get a fine, these administrative fines, you have very limited time to appeal. It's not like court. Usually it's like 10 days up to 30 days from when you get the notice. The original version of this, normally the notice had to be personal notice or certified mail. They wanted to change it to add email. We sent you an email 10 days ago, you didn't appeal, you owe the money. We did fight that. We were able to get it amended a little bit, in that they can do it by electronic notice, but it has to be some type that has a receipt. So they can't just do an email. I guess they could do the email with the click to admit you got it. If you did that, then they have a receipt. Other than that, they at least have to do something with some kind of
I always
receipt.
reject those.
Yeah.
Send a receipt? No.
Yeah. So, it makes it a little bit easier for them to come in and screw people over.
Also, the tax, the tax.
I'm gonna get there.
Oh, okay.
That's part of my presentation.
Okay, all right. So the next one, moving on to the next slide, is Senate Bill 820, the return of forfeiture. Now, this one's kind of personal to me as well, because I mean, if you read my story, I had assets forfeited from me by the feds that you know, even after going through everything, you know, everyone's like, you weren't able to get your stuff back. No, you don't get your stuff back when the feds forfeit your houses and homes. So rigorous enforcement, proposal to bring back forfeiture against unlicensed cannabis cultivators. It's worrisome, you know, because to me, that's just state overreach. So what are the alternatives? Well, like substantial fines and penalties instead of forfeiture. You know, you stick a really big fine on someone, most likely they probably won't do it again. Community service, you know, a lot of folks that I interact with that either aren't aware of their activities or they may think that their activities are legal. Community service, you know, for those that are for example, like the environmental remedies, if you're illegally taking water or pumping water or things of that nature, electricity, you perform some kind of community service as opposed to, you know, having your assets forfeited. Or even education, you know, like public awareness about illegal cultivation. I think that's, you know, is a really huge issue in that there is no public awareness. Like, for example, I have a client that does medical cannabis grows, but also is a caregiver. And they had a visit from code enforcement. What they didn't realize is that if you're a medical cannabis patient and a caregiver in Riverside County, and you cultivate, you have to have the Riverside County ID card. That is required in the county of Riverside. So if you cultivate in Riverside County for medical patients and you don't have the Riverside County ID card, then you're not compliant and you can be fined or you can penalize even though your activities are legal because the county requires you to have the Riverside County ID card. The client was not aware of that at all. So just some things that I feel that we need to do better as a community as opposed to forfeiture. And transition support. You know, there's a lot of operators that want to transition from the illicit market to the legal market. So actively trying to help those transition from the illicit market to the legal market, I think is much better approach than just straight out forfeiture. Targeting large scale operators linked to organized crime versus small scale. Like, come on, I know that there's a lot of law enforcement officers that would agree with this as opposed to, you know, well, we're just wasting our time with these, you know, potheads is what they, you know, identify us as. Well, what about those large scale operators, you know, that are linked to organized crime and do not have any intention whatsoever of doing anything legal when it comes to cannabis, to focus their enforcement efforts on that. CalNormal's intervention in this bill, the bill was amended, increasing the plant count threshold from 50 to 1,000. So round of applause for CalNormal on that. And the plants, the post-intervention and discussions from CalNormal on changing those rules and increasing those thresholds. So virtual fist bump to CalNormal on that. And then there's the overreach concerns about potential misuse and CalNormal's efforts to shed light on issues before the bill's delay on further hearings. Because yeah, this is complete overreach to me when you have the states being able to do forfeiture on when there's much, I think, more better ways to handle when it comes to illegal operations.
California, you know, has had civil asset forfeiture laws for years. And God, I'm thinking it's 25 or 30 years ago, we did major reform. 1994 or so. Was it? I know it was before I met Tina. That was when I was working with Brenda Grantlin at FEAR. And we had major reform, forfeiture in California, and fixed a lot of it, made it work. SB 820 is kind of like repealing Roe versus Wade.
Mhm.
It's like going back 30 years.
Good analogy. That's, wow.
It's very serious. It's and it's back, and Ellen just told me that there's another version of it back in the legislature. It's a horrible bill.
Do you think it'll be used against landlords that rent to
Sure.
license, against licensed
Well,
facilities?
in order, see, the whole thing with civil asset forfeiture is you're not punishing the person, you're punishing the property. The property broke the law, so you punish the property. It's from old England, where someone would go in the forest and shoot the king's deer. Well, the bow and arrow, they committed a crime. They killed the king's deer, so they take away your bow and arrow. So with landlords, there has to be some forfeitable action going on the property, and then there's what's called the innocent owner defense. So the landlord shows that one, that they didn't know it was going on, and two, that it was reasonable they didn't know. The landlord lives across the street, there's a big pot grow, they say it's not reasonable, you must have known.
What if the licensed, the facility is licensed though?
Well, again, it depends on what the grounds are for the forfeiture in the first place. So before you can go after a landlord for the property, there has to be a reason to forfeit the property.
Okay, we should probably move on.
Oh, next slide. So with all of this, what do we have? Ambiguities and uncertainties. We got varied thresholds with different plant counts across bills that lead to confusion. Senate Bill 753's definition of small with 50 plants that lacks clarity. How do you know, how is this number determined? With mature plants, seedlings, or combination, like who knows? Water rights, there's the complexities and potential misuse around water violations in cannabis cultivation. What are the parameters for a water violation under 753? Without a detailed framework, this could lead to arbitrary enforcement. Also under 756, what constitutes sufficient proof of a water delivery? So there's just these ambiguities and uncertainties when it comes to these bills. The plant enforcement trigger, that the fact that was amended, shifting the plant count from 50 to 1,000, before enforcement actions, that's the plant trigger count. That's just another ambiguity and uncertainty. Next slide, please. So,
This includes the most beautiful slideshow.
Yeah.
So now we're on to the ugly, navigating these complexities. Yeah, thank you for the comment on the picture there. I was like, how do I find something that shows what we're going through here as an industry? So the illegal and legal balance, that's really what we're talking about here. That's what this enforcement and what all these bills are about, is trying to balance between the illegal and legal cannabis markets. But where's the complexity? We have the regulatory overreach, balancing the fine line between effective oversight and stifling small business. Ambiguous water rights, like the potential for misuse and misinterpretation leading to undue legal conflicts. Forfeiture concern, challenges distinguishing between small and major illicit players and unfair targeting. And then the funding dilemma, there's that tension between state and local revenues that creates that fiscal pressure with revenue and regulation imbalance. So it's contentious issues ahead. There's a need for clear definitions, equitable enforcement, and refining the balance between revenue and regulation. So next slide. So on this one, I've reached the end of my presentation, but what stood out, as far as, I guess we have a lot of lawyers here, so I like to go over some hypo and anecdotes here. So like with these laws, like an eager client planted the allowed number of plants only to realize later that clippings for propagation counted towards his plant total. So here he was frantically doing plant math, making sure he wasn't accidentally becoming an outlaw. Like that's something that could really happen in our practice. Another one, a client is using rainwater to collect water for their cannabis plants. Little do they know, a neighbor nearby thought that they were stealing water from a shared resource and reported it. There's that misunderstanding. It's later cleared up, but it goes to show how regulations can sometimes lead to unintended neighborhood watch programs.
Yeah.
So here's a quick quiz, and to earn that CLE, which county is really lacking and really slow in cannabis expungements.
Imperial.
Imperial, yes.
Oh, but I'm not even getting a CO. Sorry. I'll shut up now.
So, thanks for rolling. Let's keep the combo burning, staying in touch.
Yeah. Yeah, let me introduce you. This is, he's already been speaking, but here is Bill Panzer, CalNorma's legal director. He's a graduate of University of California, Berkeley and Golden Gate University School of Law. He's
The
been practicing.
defunct Golden Gate University School of Law.
It's defunct.
They're closing my law school.
Oh. Why?
Nobody wants to be a lawyer anymore. They're losing money.
Oh, really?
Law school admissions are down. the whole
Lose
thing.
money with how much they charge us.
Well, because people don't want to be lawyers anymore. Because we don't make any money. It's not worth it.
Wow. Okay, can I continue?
Yeah.
He has been practicing law in the Bay Area for how long now? 30?
Now I'm in my 37th year.
37 years, specializing in cannabis defense. He's co-author of California's Proposition 215, the nation's first law legalizing the use of cannabis by patients pursuant to a physician's recommendation. In his practice, he has represented patients, growers, and medical cannabis dispensaries throughout California in state and federal court at both the trial and appellate level. You work in federal court too, right?
Oh, yes.
Oh, yeah, that's what it said. Never mind. Bill's lectured at numerous legal seminars like this one. He's a former winner of the Normal Al Horn Award, two-time winner of the Sonoma Alliance for Medical Marijuana's Compassion in Action Award, as well as, and this is important, a High Times Magazine Freedom Fighter of the Month.
Nathan D was on the cover.
So, yeah. Bill,
Well,
let's
I'm
go
also a Luddite. I have no thing to put up on there. I'm just gonna talk. A lot of what was talked about today went over my head. I have absolutely no interest in business law. Don't want to do business law. I didn't want to do it before marijuana wasn't business law, and I don't want to do it now that cannabis is business law. But all these people talking, they talk about, oh, we legalize it, it's legal. No, it ain't. It ain't legal. And what's going on, because don't kid yourself, the powers that be, the cops out there, the DAs, a lot of them, they don't like decriminalization. They think that, you know, George Soros and his liberal money people pulled the wool over the eyes of the voters, blah, blah, blah. And so they're still trying to punish people. And I'll tell you, I've got people that would much rather take the misdemeanor and the $1,000 fine than what they're looking at now. You know, and personally, I miss the days where I just went down the block and bought a dime bag. Okay, I mean, my wife and I were talking last night. If we had to actually go to the dispensaries to buy our cannabis, we'd stop. We couldn't afford it.
It's expensive.
It's ridiculous what's going on. And people ask me about the cannabis industry, and what I see, the only people really making money in the cannabis industry are people putting on seminars how to make money in the cannabis industry. So, punishment. There is still punishment out there, folks. There's both criminal and civil punishment. Criminal, I'm seeing cases. Yeah, you're right. It's they decriminalized it, first offense, growing, whatever, misdemeanor. But they add on. There's Health and Safety Code Section 11366, maintaining a place where you're storing your weed. Felony. Okay? Health and Safety Code Section 11366.5, you're the landlord making your place available to somebody else to grow. Felony. Conspiracy, felony. And I'm seeing, I had a case finishing up in Amador County. They added Revenue and Taxation Code 55363, failure to pay their cannabis tax. Felony, punishable 16 months, 2 years, or 3 years in state prison. Unemployment Insurance Code 2106, failure to furnish reports. Felony, 16, 2, or 3 years in state prison. Unemployment Insurance Code 2108, failure to make contributions. You hire somebody off of Craigslist to come in and do some trimming. Hey, you don't pay into unemployment for them. You don't make the contributions. That's a felony. unemployment insurance code section 2110.3, failure to deduct. You don't take out the deductions for the guy that you hired to trim for 3 days, felony. And people are getting charged with this, okay? Then we have,
This is real? You have real cases?
yes. I have real cases where they add these and try and get felonies. Now, it was in Amador County and they were all Chinese and Vietnamese. And, you know, gee, there's no discrimination. No, not at all. Yeah. Right. But then the other thing is the civil fines. Okay, I'm seeing people, the cops come in and now they always bring the code enforcement with them. And you know, look, there's within the statutes, if you're growing weed and you're stealing the water, you're doing environmental damage, that can make it a felony. Okay, I understand that. But they're coming in and they're fining people. And they're fining people millions of dollars. It's ridiculous. Now, also, on the state level, Revenue and Taxation Code 34015.1 came into effect in June 2022. That says you're unlicensed, you're growing, or you just have a bunch of weed, right? They can look at it and they can go, okay, we're going to assume that you were the cultivator and you owe this cultivation tax on it. And we're going to assume that you are the final retail buyer and you're going to owe all the excise tax on this weed. So they get you unlicensed, you're paying taxes the whole line, from grower to consumer. You got to cover all those taxes.
I have one of those.
Yeah, it's crazy. It's crazy. And of course, you know, Department of, well, I guess, yeah, it's DCC, it used to be BCC, now it's they're not a bureau anymore, they're a department, right? They send in some guy to go, oh, yes, you know, I haven't heard this in years, you know, every plant puts out 57 pounds that can sell for $1 million, you know, that kind of crap. And they do that. So people are getting into, they're getting these incredibly massive fines. What the hell can you do about it?
Appeal.
Well, and in Sonoma County, and I have a case right now, we have oral argument in Court of Appeal on February 6th. Sonoma County, now normally what happens is they come in, you have a zoning violation. In this case, you're growing weed. Okay, you get your, you know, your ability to remedy it. You can't pull your plants anymore. You no notice. You're that, but you have 10 days to appeal. So you have your appeal, you have an administrative appeal. And if you lose that, then you can go to court. Well, Sonoma County passed an ordinance during the pandemic that said, you know what? The county can go straight to court. We don't have to do the appellate process. Let's just go straight to court. Okay. So my client got popped with, you know, they had 4 or 5 greenhouses going, you know, growing weed. Okay. And my client asked for the appeal. And they said, nah, we're not going to give you an appeal. We're going to go to court. And they filed civilly against my client and his partner. And you know, that wasn't 10 days before the hearing. It took probably a couple of years. And they had a trial during COVID, where the trial took like 2 or 3 months because they come in that day and go, oh, we can't be in this courtroom today. We have to go across and be in another courtroom because of COVID. Or, oh, we can't have trial today, but we're going to have Zoom trial tomorrow. And it took forever. And the delay with bringing it to court right away, you know, instead of doing an appellate process, and the COVID and all that, meanwhile, the fines are adding up daily against my client. By the end, they're saying my client owes over $1 million. Now, one issue is, what kind of proceeding is this? Now, I didn't do the trial. Chris Andrian, who's a marvelous attorney up in Sonoma County. If you ever get popped criminally in Sonoma County, call Chris Andrian. If you can't get him, then call Omar. But the Omar is going to be a judge, so it doesn't matter. But no. Omar is running for judge.
I know.
Yeah, he's gonna be a judge, so, but anyway, yeah, Laura's not a criminal offense.
Lauren didn't do criminal.
No, she does the other stuff. I would, it does, whatever, call whoever you want. but Chris did the trial.
I'm okay with you calling Chris. It's all right. It's all right.
You can't afford Chris, Paul. But
There you go.
well, come on, Chris, been at it a while. So anyway, Chris went in and he argued that it was a quasi-criminal proceeding. And the county argued it was a strictly civil proceeding. What difference does it make? If it's quasi-criminal, you got certain rights. You got a Fifth Amendment right, the county can't force you to testify. You can challenge the search as illegal. Can't do that if it's purely civil. So after about 4 or 5 days of argument on the civil versus quasi-criminal, the judge ruled that it was a purely civil matter. And my client was forced to testify. The other co-defendant was forced to testify. They weren't allowed to challenge the warrant. And there were some issues on the warrant. While this is going on, by the way, they also brought a companion criminal case. And right after my client's forced to testify in the civil case, they dismissed the criminal case. It was just pressure on them. Right, so now there is a state statute, Health and Safety Code Section 11570, which is a general abatement statute. It basically says that, buildings or places used to unlawfully sell, distribute, store drugs, blah, 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 create a public nuisance or a private nuisance. And the state can come and abate based on that. The statute's been used to get, for drug houses. There's similar statutes for houses of prostitution, things like that. And cases interpreting this have found that a proceeding to abate based on the statute is quasi-criminal. But the county argues, yeah, but that's a state statute. This is a county statute, so we can abate, it's civil because it's county. Actually, they argued that it's who's bringing it, that in the 11570, it's brought by it's only brought by the district attorney. And this is being brought by county council. Well, the case that they cited for that, the first sentence in the case is, it's a LA case. This case is being brought by the city attorney. So their argument that whether or not you get criminal rights, constitutional rights, depends on who the prosecutor is, whether he's a district attorney or a city attorney or county council, is a ridiculous argument. So we're going in and we're arguing that it was quasi-criminal, it wasn't civil. And then the other argument, the big one that we're making, is under the Eighth Amendment. The Eighth Amendment of the US Constitution, has the excessive fine clause. Excessive fines are unconstitutional. And the California Constitution is, I believe it's Section 1, Article 17. Also says that excessive fines are unconstitutional. So what's an excessive fine? Well, nobody really knew until the Supreme Court in 1998, case United States versus Bakakajian, talked about excessive fines. Bakakajian got on a plane. His family was flying to Italy. He owed some guy in Italy a shitload of money. So he gets on the plane with $357,000 in cash. And when you're bringing cash out in the United States, if it's more than 10,000, you have to declare it. Just, hey, I'm bringing 357,000 with me, and that's fine. He didn't declare it. And so they found it at the airport. They found some money in his luggage, and then they talked to him and he and his wife, and they go, oh, I got 7,000, she has 8,000. But they searched him and they had like another 120,000. So the total was like 357,000. And under the statute, not only is it illegal not to report it, but you lose the money that you didn't report. So the government, as a fine, takes away the $357,000 it's forfeited. And the statute says they can do that. And the Supreme Court looked at it and said, no, not so fast. There has to be some proportionality between the unlawful conduct and the harm that it's done, so how big the fine is. And they looked and they said, what's the harm here? It was legal money. He earned it legally. He was taking it to pay off a lawful debt. The government didn't lose any money because he's taking it out. The government lost the knowledge that he's taking it out. That's it. If the government, if he did the legal thing and signed a piece of paper saying, I'm taking the money out of the country, the government would know that he was taking it out, but it wouldn't change the money. The government wouldn't get the money. And so the Supreme Court basically said, and this was their first Eighth Amendment case that they looked at, basically. They said, yes, this would make this an unlawful excessive fine. Now, California, what's interesting, if you take a look at the Bajakian case and the case that I also have in the materials, People versus Daniel Brom, Brom cites Bajakian to create this 4-factor test to see if it's an excessive fine. What's interesting is if you read Bajakian, it ain't in there. They talk about proportionality, but they don't put forth a 4-factor test. But the state Supreme Court, in a case called People X-Rel Lockyer versus R.J. Reynolds Tobacco Company, and that's 37 Cal 4th 707. That's again 37 Cal 4th 707, Lockyer versus R.J. Reynolds Tobacco, December 2005. There, our Supreme Court interpreted the Bajakian, whatever you pronounce it, interpreted that to create this 4-factor test. In Lockyer versus R.J. Reynolds, what that was, California passed this law that says you can't give out free cigarettes, and especially to minors. Some of you may be old enough to remember that cigarette companies used to go to events like, in this case, it was drag races in Pomona, and give out free samples, a little pack with like 4 cigarettes in it, free samples of Marlboro, free samples of Parliaments, whatever. And R.J. Reynolds had gone to the Attorney General in California and asked about, we want to give out these cigarettes, but we'll do it private property, Pomona Raceway. We'll have a tent with no signage on it. No kids will be able to see us give out these cigarettes. Is that okay? The Attorney General said, it sounds pretty good to me. So they went and did it. And they were supposed, I think the fine is from $100 to $500 for each time you violate the statute. And basically what they came down with is R.J. Reynolds was fined over $14 million. And so the state Supreme Court came out with this 4-factor test, which was then used by the Court of Appeal here in I believe it was San Francisco, actually. No, I'm sorry, this was in LA. People versus Daniel Brom, which was a cannabis-related case. Brom was a landlord, rented out a couple of locations in LA for dispensaries. LA passed a law that says, you gotta be licensed, and Brom, you ain't licensed. Cease and desist. Brom ignores it, goes ahead and lets the dispensaries go for another year or two. And they come after him for fine. I think the total was about 500,000 or something. I have it written down here somewhere, whatever. So yeah, so they fine him. He says, well, double jeopardy because you also did a forfeiture. Yeah, the total fine was just under $6 million. Court of Appeals said, well, it's not double jeopardy because the forfeiture was actually a different time period than the fine covered. They overlap some, but they weren't. So it's not double jeopardy, but the excessive fine. And so they look at the 4 factors. And the 4 factors, oh God, I have them written down here. The defendant's culpability, the relationship between the harm and the penalty, the penalties imposed in similar statutes, and the defendant's ability to pay. So the case that I have right now in Sonoma County, defendant's culpability, what I'm arguing is, yes, my client has some culpability, but it's not all on him. Part of it's on the county. If the county had given my guy the appeal when he asked for it, instead of delaying it and going to court and stuff, it would have happened faster. Also, a lot of this delay is because of COVID. If COVID wasn't happening and the courts weren't stripped down and they were running, regularly, he would have gotten to court much quicker. So culpability, it's not all his culpability. Then the relationship between the harm and the penalty. The county, the attorney in his opening statement talked about the damage to the environment being caused by the chemicals involved in this grow. He made a big deal about that. The evidence at the trial was there was also an alleged hash oil lab. And the alleged hash oil lab had ethyl alcohol in it. Ethyl alcohol is the kind of alcohol that's in the drink that you're gonna have after this is over. It's in the beer, it's in the scotch, that's ethyl alcohol. It's not considered a volatile chemical by California regulators. There was no other chemical found. So I pointed, what's the harm? There was no testimony of any harm. Third, the penalties imposed in similar statutes. I noted that in Sonoma County, if you are violate zoning ordinance by growing corn in the wrong place or other agricultural products, it's a $500 fine, not $1 million. I also pointed out that, on the relationship between the harm and the penalty, that if one of the reasons why the penalty was so high was because cannabis can it's psychoactive, it's a dangerous drug, if they want to argue that, they don't differentiate between cannabis and hemp. So you got the same fine with hemp, so that's not the reason why it's dangerous. So the penalties imposed similar statutes, again, I pointed out, also prior to Sonoma County passing this, back when, before Prop 64, before 2016, Sonoma County's ordinance, legally grown marijuana, $500 fine. The county said that I made a mistake in their reply group. They said it wasn't 500 back then, it was 1,000. I said, well, 500 versus $1 million versus 1,000 versus $1 million, that ain't much of a difference. So I pointed that out. And then the final thing, the defendant's ability to pay. I argued the defendant testified that the county wanted him to remove the greenhouses, and the permits for that was $64,000, and he couldn't afford it. And when they reduced it to 1,600, then he could afford it. He pulled the permits and he put out his greenhouses, because the excessive fine issue never really came up at the trial level. So I had to go through it to find what I could do. So I think that we're going to see more and more of these cases, more and more of these ridiculous fines. And, the Eighth Amendment is one way to try and go at it. The quasi-criminal proceedings, another way to go at it. We want to get to see the 49er name. One other thing I want to just throw out there, another thing that I'm doing right now. And if anybody, I just want to put the idea out there, other people you might help in your practice. I have a client who is top in Lake County with, in his back seat, a few boxes with, a few hundred clones, really small clones. I'm insisting that they test them, because people I'm talking to are telling me the chances are that those clones will have less than 0.3% THC in them.
Yeah.
If they got less than 3.3%, they ain't illegal cannabis. That's him. So, the DA was like, we don't test marijuana anymore. I said, well, you guys want to test it, or I'll have a lab and they'll test it. So we'll send it to the state. I said, okay, great, let's see what happens. So that's my story. I'm sticking to it. If anybody's got any questions, I know we were running late, so I was trying to make it a little quicker.
Thank you. There are some questions online, but for some reason I'm having trouble accessing them. For some reason it's, Lauren, can you see the questions from where you're at?
And 1 minute, let me see if any of these are for this one. Okay, so forfeiture is still alive and well in California without SB 820. I just resolved a pre-COVID matter a couple weeks ago in Amador County. That's more of a comment than a question. Then we have another comment. Good stuff. Thank you so much. Okay.
Aw.
And then another comment, something about client in Amador County initially charged with felony conspiracy in addition to 11-358, 11-359 prior to 17B at prelim. This was okay, about 20 minutes ago. Charges tend to vary about county because there's really no questions. These are kind of just more comments on things that we're saying.
And they did that to our clients in Amador too, but the three counts for the cannabis we got thrown out for the statute of limitations. They waited more than a year to file it. And since they're misdemeanors, it's a 1-year statute of limitations.
Okay. All right, well, is that all, Lauren? Those the questions?
That's all. I have a question for Bill. Bill, who was representing the county in that case? Which county council?
It started out with a guy named Rob Truncheon, I think his name was. And then he quit and we had like 2 or 3 others that would like have the case for one hearing. So
Yeah.
they kept like passing it off because nobody wanted it.
Yeah. Okay, that sounds like them.
Okay, so you can see a preview of our final panel. Her sheet is going to be coming in about 15 minutes. We're going to take a quick break. The